Please, Your Lordship. Your Lordship, I beg to mention item number 9.
Number 9?
Yes, Your Lordship.
I think this matter has been heard.
Yes, Your Lordship. They're supposed to supply a copy of the report, the opinion report, Your Lordship, so they have not supplied as of till present.
Who's supposed to?
The school respondent.
You have,
Will supply today, Your Lordship.
you have a respondent
3, 4, and 5.
on pre-made by the respondent, counsel for the respondent 1, 3, 4, and 5 seeking accommodation. Matter is adjourned. This is after 1 week. 1 week?
2 weeks time, Lordship.
2 weeks.
Lordship, there was direction also for the state respondent to supply.
You have not done so.
We have received this, whatever, on the last occasion, we have asked for the original copy of the report. Then they send us the original copy of the writ petition.
So do that within the next date fix.
We will do that later.
Highly obliged.
Please, Lordship. Lordship, I'd like to mention item 10, my lord. Last item. 10.
Yes.
Criminal appeal, Lordship. I'm praying for a short accommodation today, my lord.
Let it come after 2 weeks.
23 doesn't matter.
23. Lordship.
On pre-made by the appellant, this is matter after 3 weeks.
3 weeks, man. Much obliged, Lordship.
May it please your Lordship, I beg to mention item number 7. Lordship, I pray that this matter comes up after 2 weeks.
What is this matter?
Regularization, your Lordship.
On pre-made by the petitioner, this is matter after 3 weeks.
Obliged, your Lordship.
From daily list, item number 1.
Please, Your Lordship.
Yes, Mr.
Lordship, in item number 2 and 3, Lordship, I am praying for some more accommodated time, Your Lordship, because the matter is pending now before they're in the process now to make all those filings because it's a long process, Lordship, regarding the compounding, Lordship.
So you have not even filed your application before the ROC?
Lordship, because with regard to Amrit Cement, they're in the process now, they'll be filing it. But with regard to the item number 3, the board has just approved for compounding. So, Your Lordship, there'll be, once it is approved now, so they just need to appoint a chartered accountant like to do the necessary in Guwahati, Your Lordship.
Yes, Mr.
My lord, we are yet to receive any compounding petition. 3 and 4, my lord. Item number 3 and 4.
So I'm praying for a long date, Your Lordship, then I'll come with appropriate instructions.
Mr. P. Nambril and counsel for the petitioner has submitted that the petitioner is in the process of filing an application for compounding of the offence. The same to be filed before the Register of Companies. And as such, some time is prayed for the process to be completed and a report to be and for this court to be apprised
Your Lordship,
of the
status.
Status. So same order will be here also.
Your Lordship, 2 and 3, Lordship.
2 and 3, same order.
2, 3, 4, Your Lordship.
That is so 2.
Yes, 2, 3, and 4. These are all identical, Lord.
So 2, 3, and 4. See, number 2 is Amrit Cement.
Number 3 is
3
Manipur.
and 4 is Manipur. So you are also in the process of filing the
Yes, all this.
What was again? On premier by the on consideration of the premier, the same not be objected to by the respondent. The matter is accordingly adjourned for the day. This is the same after 3 weeks. 3 weeks?
It can be a longer date, 6 weeks.
Why?
I'll come with proper
Agreeable.
instructions.
As prayed for, this is matter of 6 weeks.
Obliged. Much obliged.
Item number 5.
Well, it's a limited issue involved in this matter is here's a list of dates. Please give me the list.
Yes,
Yes, my lord.
we are.
Yes, my lord. I'm today. I'm with it. My petition, lordship. There was due to some technical fault. The petition. The registry has not accepted my petition. It's already ready, but due to some technical fault, the death certificate copy of the death certificate is not clear. So the registry has asked to rectify that. I'll be filing it by tomorrow once I xerox the rectified.
Well, that is okay, but there is a little technical hitch because respond number 1 has been deleted from the array of parties.
Oh yes.
So insofar as the locus of my learned friend is concerned, well, it's to seek a accommodation in this matter would be a little difficult because your lordships would have to pass an order on behalf of some respondent.
Exactly.
There is no respondent. There is nothing. Nobody is on record. It's only the state.
What this court has agreed to when the submission was.
I've seen the last order, Malad 16.2. Your lordships have permitted.
File an appropriate application.
Lordship.
So that will be tested,
Independently.
in accordance with procedure and law. Or this is criminal. This is a revision petition.
Because the difficulty is, Malads, that since respondent is Malads, it is only as against the state today. And I had submitted before lordships. It's only on a legal issue that your lordships have to decide this issue.
But see, Mr. Paul, the fact remains that the court has to look into who would be the affected, party person.
What I submit before your lordships is, my lords, no right to sue survives. Insofar as the respondent number 1 is concerned, I had submitted before your lordships even at the early stage. I can demonstrate, my lords, why right to sue does not survive. If my friend wants to make an application, my lords, I'll have to file a response. That's okay.
That's the only thing.
My lords. Because the issue here, my lords, the impugned order of the deputy commissioner did not deal with a question with regard to the jurisdiction of the deputy commissioner to decide that application. Because what the act says is, my lords, it says the commissioner secretary. The expression used is commissioner secretary. Now, the Meghalaya General Clauses Act, my lords, clarifies on who's the commissioner secretary and what it distinguishes between commissioner secretary and deputy commissioner. This deputy commissioner is, my lords, subordinate to the commissioner secretary. That issue was wrongly decided by the deputy commissioner at the initial stage. Matter went up in appeal, my lords, and there is no finding with regard to that issue. So that goes into the merits of the entire matter.
So it's a question of wrong assumption of jurisdiction.
Jurisdiction. I can take your lordships to the finding of the deputy commissioner. Your lordships
That is the
can
case.
listen.
You see, then the case would hinge on a technical.
Purely on a question of law, my lords.
Lordship, I am the being the questions. It is the order is in my favor, Lordship.
The order is not in your favor. Had it been in her favor, my lords, I would have to substitute her. I cannot say that the right to sue does not survive. I'll just take your lordships to the impugned order. Your lordships would find it at page 49. I'm sorry, this is not page. Just a second. Just take out the list of dates, please. The first order of the deputy commissioner. Because if my learned friend was a beneficiary of that order, my lords, at page 50, then, my lords, the right to sue would survive. The lordships would have the order dated 27/5/2013. Lordships have it, my lords. At page 50, annexure 13. Well, I'll very quickly read this. Brief facts of the case is that petition was filed by one Shri Prabhushini Datta for restoration of patta in her favor. My lord, so that is the prayer. Restoration of patta in her favor. In respect of revenue plot number so-and-so, in the said petition, petitioner has stated that she is the possessor and owner of revenue plot number so-and-so, which was duly purchased by Shri Radha Vinod Chaudhary, the original allottee, that the petitioner had executed a general power of attorney in favor of Ranabir Chaudhary to get necessary paperwork done. However, Ranabir Chaudhary, being an advocate himself, got the patta done illegally in his name, who is neither the real owner nor the purchaser of the said plot of land. He did it so by misleading the authorities and manipulating the facts. After taking cognizance of the facts mentioned in the petition, notices were duly issued to both the parties and sufficient opportunities were given to prove their claims and counterclaims, and by order dated so-and-so, Ranabir Chaudhary had directed to explain his identity in relation to Radha Vinod Chaudhary but failed to prove the same. This case came up for final hearing on 21/3/2013, when the petitioner once again stressed her claim for prayer for cancellation of patta issued in favor of so-and-so in view of letter dated so-and-so written by Deputy Commissioner, forwarding the view of the Advocate General of the Meghalaya, who opined that the Deputy Commissioner may go ahead in this matter as per Rule 26 of the Settlement Rules. Please take out to Rule 26. The OP submitted that as per Rule 26 of the Settlement Rules, the Commissioner shall have the power to confirm as well as cancel all settlements. He has also referred to Section 315 of Meghalaya Interpretation and General Clauses Act 1952, which reads, Commissioner means the chief officer in charge of the revenue administration of a division. He also submits that the concerned officer by this definition and interpretation will be the Commissioner and Secretary in charge of the Revenue Department, Government of Meghalaya. And thus the OP prayed that the matter be referred to the concerned officer for appropriate disposal. After going through the submissions and the documents placed by the parties, Rule 26 of the Settlement Rules, Meghalaya Interpretation of General Clauses Act so-and-so, this court is of the opinion that it is well settled principle of law in Meghalaya that the Commissioner and Secretary Revenue Department shall have the power to confirm and cancel all settlements in the division, which may consist of a number of districts, and Deputy Commissioner of a district, after following due process of law, refers the matter either for confirmation and settlement or for cancellation of settlements done in his district to the Commissioner Secretary of the Revenue Department of the government. That being the settled principle of law, I am of the opinion that the plea of so-and-so is not maintainable and hence cannot be considered. Moreover, O.P. Downabir has not been able to prove his identity in relation to Radha Vinod Chaudhary as by the court. Therefore, the prayer of the petitioner is allowed. The patta settlement of so-and-so, presently in the name of opposite party, is hereby referred to the authority concerned for cancellation of the same. So it is only a question of cancellation, my lords. There is no counter settlement in favor of the original complainant. Had there been a settlement, my lords, of course, then it would have been a different case. Now, the issue to be decided is, my lords, Rule 26 is very specific. It says Commissioner Secretary. The finding at page 51, the first part, my lords, establishes that finding. I'll read it again very slowly. After going through the submissions and the documents placed by the parties at Rule 26 and Rule 26 of the Settlement Rules and Section 315 of the Meghalaya Interpretation and General Clauses Act 1952, This court is of the opinion that it is well settled principle of law in Meghalaya that the Commissioner and Secretary, Revenue Division, Revenue Department, Government of Meghalaya shall have the power to confirm or cancel all settlement in its division, which may consist of a number of districts, and Deputy Commissioner of a district, after following due process of law, refers the matter either for confirmation or settlement, for cancellation of settlements done in his district to the Commissioner and Secretary of the Revenue Department. It's a pure question of, my lords, quorum non judice. When the law makes a provision, my lords, under Rule 26, I'll take your lordships to Rule 26. Where have you quoted it? There's a book. I'll take your lordships. I'm told, my lords, by my friend that it is quoted. My lords, if your lordships can have page 10 of my revision application. I'll take out not Meghalaya. This is the general. Get me Meghalaya.
Yes.
Well, it's the petitioner, for the convenience of this honorable court, seeks liberty to reproduce Rule 26 of the rules framed under the Meghalaya Land and Revenue Regulation as hereunder. Rule 26. Subject to the general control of the state government, the commissioner shall have the power to confirm and all settlements and also to cancel any settlement made in contravention of these rules after giving the leaseholder an opportunity of being heard. The definition of commissioner and deputy commissioner is found under section 315 and 20 of the Meghalaya Interpretation of General Causes Act 1972 and is reproduced. 315 deals with commissioner. Commissioner means the chief commissioner in charge of a revenue administration of a division. And 320 minutes deputy commissioner means the chief officer in charge of a general administration of a district. So the power under Rule 26 has to be exercised, if at all, by the commissioner. So it is only on that fundamental issue, Millets, that this matter becomes erroneous in law.
So the deputy commissioner who had signed the impugn order,
My lords.
is not also holding charge as a commissioner.
No, my lords. Commissioner secretary is a promotional post.
True. No, but here doesn't say, you see, rule doesn't say it's commissioner and secretary.
He says deputy commissioner, specifically says deputy commissioner.
It says commissioner, the definition is given of commissioner and deputy commissioner.
Commissioner. So, my lords, unless somebody, the authority who's passing the order, my lords, is vested with that power under the law, any order passed becomes non-est in law.
This would have been a simple matter. This court will just remand the matter to be...
The matter has to go back to the appropriate authority.
Appropriate authority has to decide the matter, because the merits of the dispute is not to be decided here.
The merits, we are not on the merits also, Lordship. Lordship, what happened is that, Lordship, if according to the order, Lordship, according to the page 51, the order says that the cancellation of the patta, and also it says that the petitioner, that is in the lower court, the petitioner is, I am the petitioner. So the petitioner's case is well established. So now if my case is well established, if I am not being substituted in this case, I am not being heard.
You will be in due course, you will be allowed. Perhaps this court will also, while passing the order, will give you an opportunity to be heard before the relevant authority. The only issue here is the matter should have been heard by the commissioner. Instead, it was heard by the deputy commissioner, or rather taken up.
Lordship.
The order was also passed by the deputy commissioner, when revenue matters should have been taken up by the commissioner as per the Rule 26. It would have been a very simple matter.
It's a question that goes into the root of the entire matter. Other than that, this is all.
Yeah, so where is your? In fact, as far as this the present case is concerned, the government will be here to support its case,
Lordship.
which will support you in any case.
Lordship.
They will defend this impugn order if required.
Lordship.
Well, they'll not be able to defend this impugned order, because there is, on the merits of the matter, there is a difficulty. The merits of the matter is, my lords, post 1972, the petitioner who's here before Lordship does not claim to be the original allottee. She says, I purchased the land from Radhabin Chaudhary post 1972. In view of the bar under section 3 of the Land Transfer Regulation Act, my lord, she has no title. If I have to go in, my lords, assert my title before an authority, I would have to first show.
Exactly.
But that would be considered at an appropriate stage.
Yeah, we are not on that.
Absolutely, my lords. Because your lordships will see from the impugned order, we had pointed out to the deputy commissioner, you do not have the authority in law to hear the merits of the matter. That's why there is no discussion of merits. But there are certain findings. He's not been able to prove this, he's not been able to prove that. My lords, the question remains, if you do not have an authority to direct me to prove something, where is the question of me proving something before you? And the other difficulty is, my lords, he becomes, and why the commissioner comes in, my lords, I must clarify why the law provides for commissioner. Settlements, the original settlement, my lords, the settlement officer, as per the rules, your lordships would be aware, is the deputy commissioner.
Yes.
So his predecessor in interest, my lords, the officer who passed the order, his predecessor in interest, after being satisfied of my title, had issued the lease agreement in my favor. Naturally, my lords, this office becomes functus officio. So if any party is aggrieved by that, my lords, that's why Rule 26 makes a provision that you go before the commissioner, who is the commissioner of the division. Under him, my lords, all the deputy commissioners of the state would come in, and he would then apply his mind judiciously whether it was rightly done or wrongly done. So he can either confirm it or cancel the confirmation. It's a limited issue.
Lordship, the letter, the orders, and everything, it is passed. It is mainly confined with the
See, Miss Bhattacharjee, this court cannot hear you.
lordship.
So the only thing is that if we are to hear this case on merits, as far as this matter is concerned,
Lordship.
then you have to be reckoned in a proper manner. But that has not been that. So if we go through that process, then again the matter will linger. If you choose to abstain from these proceedings and let the government fight for your case, eventually, if the matter is remanded, that observation will be there, then you will be allowed to contest the matter on merits. It's up to you. Of course, whatever the case may be, so that we'll not delay on the proceeding.
Yes, my lords, I examined this entire matter in its entirety, and that's when I realized, well, it's on a very limited issue of law.
Lordship, I was according to the last order dated,
Yes.
I was directed by this honorable court to file a proper application. Lordship, today by today I would have filed a proper application, but due to some technical faults,
that is also accepted.
that due to some
Well,
technical
lords,
faults,
if I may, just to be fair to my learned friend, let her application come your lordships with then.
That's the only thing.
I will not go say anything further
I was about to say
in the face of your lordship's order. My lords. I will not say. I must respect any orders that have fallen from your lordships. But your lordships had given an indication to my learned friend, my lords, probably that would have been more beneficial. Be that as it may, my lords, my habit. Let's make copies of these two.
Ms. P. Bhattacharjee, Learned Counsel, has submitted that in view of the order dated 16/2/2024 passed by this court, an application was referred before this court. However, due to some defect in the application, the registry, the same was required to be rectified, was required to be corrected. Accordingly, it is prayed that some time may be allowed for the proper petition application to be brought to the records of this court. On premium, it seems allowed. This matter after 1 week.
They come after the vacations. Obliged.
Item number 6.
whether my lords would grant me liberty to my lords file an objection also. If my learned friend files it, I can file an objection and then your lordships can hear the matter. Since in substance I have already placed the facts of the matter before your lordships.
That's what in the even the said application is to be filed with advance copy to all concerned who may file an objection if so advised.
Nice. Obliged.
Yes. Yes, please.
Your Lordship, Mr. SN is the conducting counsel and he's on legs, Your Lordship, in court number 2. Let the matter come up after a week, Your Lordship.
On pre-made by the manager on behalf of the state petitioner. Matter is adjourned. Let's the same after 2 weeks.
Obliged, Your Lordship.
Item number 8.
Yes, Mr. Thapa.
Your Lordship, as I submitted last date, my lord, the petitioner hearing has expired already.
So,
Of course, we do not have any proof, but then we came to know about it through newspaper reportings, my lord.
that is true. That was the same submission you made the last time.
Yes.
around.
No, my lord, on the
You said
last
that
date.
you will get some confirmation and
Yes, on the last date, my lord, in fact, some confirmation was required. Your Lordship had sought for some confirmation from the State Department, my lord, since he was under employment under the state government. And if I think Sir has brought something.
This is
Sir
Your
has
Lordship.
brought
Lordship, so far the death certificate is concerned, Your Lordship, we are yet to get it because the family member of the deceased, Your Lordship, has not.
No, if the death is confirmed by the state government, my lord,
Lordship, we
we can
can't-
close this matter, my lord, since it has now become infructuous in view of his expiry, my lord.
yes.
If it
that
is
is the case,
confirmed
then-
from the state government, since he was under state employment, my lord, if it is confirmed from the State Department that he is dead, then there's no point pursuing with this matter any further, my lord.
Death certificate is yet to be produced by the relative of the deceased in this office.
But if it is confirmed that he has expired, and we can close this matter, my lord.
That we cannot say. It's firstly is it is the honest you.
Yes,
he
my
was.
lord, like I said,
he was.
correct.
Is or was, we don't know, but he was your client. It's incumbent upon you to make inquiries.
My lord, the only difficulty we are facing with this matter is, my lord, he was in contact with us personally, my lord. His family was not involved at all. So we don't even have a contact number of the family, my lord. He was solely in contact with us in his personal capacity. That is the difficulty we are facing. Otherwise, we would have brought that certificate on record, my lord. And we do not know whether his family still resides in Shillong or is not in Shillong.
So that leaves us with only one option. Even then, you still have to be instructed if you have to withdraw the matter or.
The difficulty, my lord, like I said, we don't have the phone numbers even of the family members. We don't even know whether the family members are still in Shillong or they are outside Shillong, because all along the petitioner in his personal capacity was in contact with us.
Mr. Shulai, last time around, I think this court has impressed upon you to, you are his employer. So
Yes, Your Lord.
you could have got the records, you could have got the confirmation, you could have, confirmed that he is, actually the petitioner herein.
Going by the construction of the letter, Your Lordship, yes, he is our employee only because. Kindly see, Your Lordship, the copy of the death certificate of late is yet to be produced.
Yeah, yet to be produced by their relatives.
By the relative, yes. Only a confirmation, Your Lordship. That is a certificate is only confirm, Your Lordship. Otherwise, Your Lordship, going by this letter, it's appear that yes.
We can take this letter on record and my lord can close this matter since the matter now has been rendered infructuous.
This letter has, is not, affirmative in any sense.
Absolutely, my lord.
The only thing is, if this letter has been worded by the department in such a way that yes, his debt is confirmed.
Yes.
However, we could not, as of now, we could not procure the debt certificate. That would have been different. What do we do, Mr. Shulai? Tell me.
Lordship, because going by this letter, Your Lordship, in my humble and respectful submission, Your Lordship, the debt is confirmed, Your Lordship. Only a certificate is being awaited by the police, state police.
We'll wait for the certificate. Try to get the. It is the submission at the bar that the debt of the petitioner herein is confirmed. However, all the concerned parties, including the authority, including the employer of the petitioner, could not produce the death certificate to prove the demise of the petitioner. The learned counsel for the petitioner also has no specific instruction as regard the proceedings of this matter under such circumstances. It is as prayed for by the party. As prayed for by parties, the death certificate is allowed to be brought on record by either of the parties within the next date fix.
Let it come
He
after.
He was a native of which area? Shillong.
He originally, if I'm not wrong, he belongs to. His father was from Shillong. He was also under employment of the state government, but he originally hails from Silchar, if I'm not wrong. Silchar or Tripura, but not from.
You will have contact.
It will come after 6 weeks, Your Lordship. I'll instruct the SP to get it directly from Korkaun, Your Lordship, from the place of accident.
From his records, you will get to know the next of kin. You'll get to know the nominee. All those particulars have to be there.
Lordship, let it come after 6 weeks. We'll do the needful, Your Lordship.
So, madam, you are aware of the situation?
I just want to update the court. We know that he has a case also against him in Ripoy. So maybe you can connect with the police there, SP, then you can get the details.
This letter was written by the
This
SP.
letter also was given by the SP.
Ripoy.
Ripoy district.
Because they'll have to even update the court in Ripoy.
Yes. So you keep
let it be 6 weeks, Your Lordship. We'll do the needful accordingly, Your Lordship.
On primate, this is matter of the 6 weeks.
Apply, Your Lordship.
Sure.